Hello and welcome. If you've inherited assets or property in Italy, you might be wondering how the Italian probate process works. Whether there's a will or not, the Italian legal system has specific inheritance laws for succession. In this video, I will walk you through everything you need to know about probate in Italy, the applicable law, the role of heirs, the importance of a will, Italian inheritance tax, and much more. Stay tuned. First, let's clarify, in Italy, the term probate, as in the UK legal system, does not exist. Instead, we talk about succession hereditaria. When a person passes away, their Italian estate, including property in Italy, bank accounts, and other assets, must be transferred to their heirs according to Italian succession law. This process depends on whether the deceased left a will or not. Which inheritance law applies to an estate in Italy? According to EU Regulation 650/2012, the law of the deceased's last habitual residence generally governs probate in Italy. However, if the deceased was a UK national, they can choose UK inheritance law to apply by stating it in a valid will. This is crucial for British expats in Italy or those with cross-border Italian assets. Now, what happens if there is a will in Italy? If the deceased has left a valid Italian will, it must be published by a notary in Italy. If there is no will, Italian inheritance rules apply through legitimate succession legitima, meaning the Italian estate is distributed among the closest relatives, spouse, children, and parents if applicable. Italy has a system of forced heirship legitima. This means that certain heirs, typically the spouse and children, are entitled to a minimum share of the inheritance, even if the will states otherwise. This system protects family members from disinheritance, ensuring they receive their lawful portion of the Italian estate. Heirs in Italy can accept or reject an inheritance in Italy. If an estate has more debts than assets, heirs can renounce, rinuncia or the redditor. This must be done formally before a notary or at an Italian court. If heirs accept the inheritance with benefit of inventory, accettazione con beneficio di inventario, they limit their liability for Italian estate debts. A key step is the declaration of succession, dichiarazione di succession, which must be filed with the Italian tax authorities within 12 months of the death. This declaration lists the Italian assets and calculates Italian inheritance tax. Inheritance tax rates in Italy depend on the relationship with the deceased. Direct heirs pay 4% tax over €1 million, while other relatives and non-relatives pay higher rates. To summarize, the Italian probate process involves white heather checkmark determining the applicable inheritance law, white heather checkmark identifying heirs with or without a will, white heather checkmark managing forced heirship rules in Italy, white heather checkmark accepting or renouncing the inheritance, white heather checkmark filing the declaration of succession in Italy and paying inheritance tax. Navigating this process alone can be challenging, especially for British nationals inheriting property in Italy. At Mangata Avvocati, we specialize in assisting UK clients and expats with Italian probate matters. If you need help with Italian inheritance law, contact. Thank you for watching. Don't forget to like and subscribe for more legal insights on Italian probate and inheritance law. See you next time.